Okay, good morning everyone. I am Bukog J. Mark Danieles from BS Criminology 3 Delta. Today I'm going to show the audiovisual presentation activity number 8A. 8A with the following topics. Okay, let's go to first page. The General Considerations, Book 1, Theories of Criminal Law. Okay. Let's go to first topic. Classical theory enunciates that number 1, man is essentially a moral creature with an absolutely free will to choose between good and evil, and therefore more stress and placed upon the result of felonious act than upon the criminal himself. Number 2, basic criminal liability is human free will, and the purpose of the penalty is retribution. It endeavors to establish a mechanical and direct proportion between crime and penalty. Number 3, crime is a judicial entity and the penalty is an evil and a means of juridical tutelage. Okay. Number 4, there is a scant regard to the human element. Okay, that's it. The classical theory enunciates. Let's go to another topic in page 1. Positivist theory posits that number 1, man is subdued occasionally by a strange and morbid phenomenon which condition him to do wrong in spite or contrary in his violation. Number 2, crime is essentially a social and moral phenomenon, and it cannot be treated and checked by imposition of punishment, fixed and determined, but through the enforcement of individual measures in such particular case after a prior investigation conducted by a competent body of psychiatric and social sciences. Number 3, the positivist theory. Number 3, basis of the criminal responsibility of the criminal is his dreadfulness or his dangerous state. That's it. The topic, the positivist theory. Let's go to page 2. Compendia of Revised Penal Code, Book 1 and Book 2. The Revised Penal Code is mainly based on classical theory, although there are some provisions of the code which are positivist, like Article 4, second paragraph, and Article 13, paragraph 7 on mitigating circumstances of voluntary surrender. This page number 2, the effectiveness of Revised Penal Code. The Revised Penal Code took effect on January 1, 1932. Article 1, Revised Penal Code. Okay. This page is the effectiveness or effectivity of the Revised Penal Code. Okay, let's go to page 3. An act revising the penal codes and penal laws. December 8, 1930. Simplified elements and Article 1 to 113. It means it is simplified articles from 1 to 113, Book 1, with updates in criminal law. Preliminary article, this law shall be known the Revised Penal Code, Book 1. Book 1, the general provision regarding the date of enforcement and the application of the provisions of this code, and regarding the offenses, the person liable, and the penalties. This book is for criminology students. Okay, let's move on to preliminary title. Date of effectiveness and application of the provisions of this code. in the Article 1, time when Act takes effect. This code shall take effect on the first day of January 1932. Okay. Time when Act takes effect on the first day of January 1932. 1932. Okay. Definition of criminal law. Criminal law is one that defines crimes, traits of their nature, and provides for their punishment. Crime is an act committed or omitted in violation of public law. Public law. Okay? That was the crime, okay? Let's move on to page 4. Compendia of Revised Penal Code, Book 1 and Book 2, okay? The criminal law in the Philippines. The Revised Penal Code, Act number 3815 and its amendments. Number 2, special penal laws passed by the Philippine Commission, Philippine Assembly, Philippine Legislature, National Assembly, and the Congress of the Philippines, and Batasang Pambansa. Number 3, penal presidential decrees issued during the martial law. Okay, let's move on to common laws. Common law crimes not recognized in the Philippines. The so-called common laws crime. The so-called common law crimes known in the United States and England as the body of the principles, usage, and the rules of action which does not rest for their authority upon any express and positive declaration of the will of legislature are not recognized in this country unless there be a particular provision in the penal code, a special penal law, that defines and punish the act, even if it be socially or morally wrong. No criminal liability is incurred by its commission. Court decision not sources of criminal law. Court decisions are not sources of criminal law because they merely interpret the meaning of the applied law and considers the evidence presented and finally determines the rights of the parties. Example of court decision interpretation of the law is the following. Okay, under Article 8 of the Revised Penal Code, there is conspiracy when two or more persons come to an agreement concerning a felony and decide to commit it. It may be inferred from the acts of the accused before, during, or after the commission of the crime, which, when taken together, would be enough to reveal a community of criminal design, and thus a proof of conspiracy is frequently made by evidence of a chain of circumstances. Okay? To be a conspirator, one need not participate in every detail of the execution. He need not even take part in every act, or need not even know the exact part to be performed by the others in execution of the conspiracy. The precise extent of or modality of participation of each of them becomes secondary, since all the conspirators are principals. Nolam crimen, nola pena sine lege. No crime where there no law is punishing it. That's the meaning of that Latin word. Nolam crimen, nola pena sine lege. No crime where there no law is punishing it. Let's go to page 5. Page 5. The preliminary title. The state. The state has power to define and punish crimes. The state has the authority under its police power to define and punish crimes and to lay down the rules of criminal procedures. States, as a part of their police power, have a large measure of discretion in creating and defining criminal offenses. Okay. Limitation on the power of lawmaking body to enact penal legislation. It is their limitation of in making a lawmaking body. Okay, the Bill of Rights of 1987 Constitution imposes the following limitations. No ex post facto law. Yes, no ex post facto law or bill or of attainment shall be enacted. Article 3, Section 22. Number 2, no shall be held to answer for criminal offense without due process of the law. Can be seen in Article 3, Section 14. The first limitation prohibits the passage of retroactive laws which are prejudicial to the accused. An ex post facto law is one which makes a criminal act done before the passage of the law, which was innocent when done and punishes such an act. That's the ex post facto law. Okay, let's move on to page 6, Compendia of Revised Penal Code. The Bill of Attainder is a legislative act which inflicts punishment without trial. It is a substitution of the legislative act for a judicial determination of guilt. That's the Bill of Attainder. Okay, let's move on to another topic. The Favorabilia Sant Amplianda Odiusa Restringenda. Okay, it means penal laws favorable to the accused are given retroactive effect. That's what it means. Okay. Exemption in the case of habitual criminal, Article 22, Revised Penal Code. Also with prospective effects are Republic Act 7559. Let's go to death penalty. Republic Act 7890, increasing the penalty for grave coercion. The new rape law. That's it. Okay, let's go to another topic. The penalty of prison mayor, medium or 8 years and 1 day to 10 years imposed by Presidential Decree 818 applies only to swindling by means of issuing bouncing checks committed on or after October 22, 1985. Let's go to this topic, another topic. The right which may be waived is the right of the accused to confrontation and cross-examination. The right which may not be waived is the right of the accused to be informed of the nature and cause of accusation against him. It's just like seeing the Miranda Doctrine, okay? The reason of principle underlying the difference between rights which may be waived and rights which may not be waived is that those rights which may be waived are personal, while those rights which may not be waived involve public interests which may be affected. Okay, let's go to another topic, the characteristics of criminal law. Okay, criminal law has three main characteristics. Number 1, the general. Number 2, territorial. Number 3 is prospective. Number 1, the general. And that criminal law is binding on all persons who live or sojourn in the Philippine territory in Article 14 New Civil Code. Okay, that's the characteristic of criminal law. Let's go to another topic and page 7. Civil courts have concurrent jurisdiction with general courts martial over soldiers of armed forces of the Philippines. As a general rule, the jurisdiction of the civil courts is not affected by the military character of the accused. The code or other penal law is not applicable when the military court takes cognizance of the case. The prosecution of an accused before a court-martial bars another prosecution for the same offense. A court-martial is a court, and the prosecution of an accused before it is a criminal, not an administrative case. And therefore, it would be under certain condition a bar to another prosecution of the accused for the same offense, because the latter would place the accused in the double jeopardy. Okay, let's move on to another topic. War crimes and triable by military commission. Accused is indeed a war criminal subject to jurisdiction of military commission. War is not ended simply because hostilities have ceased after cessation of armed hostilities. Incidents of war may remain pending, which should be disposed of as in time of war. A military commission has jurisdiction so long as technical state of war continues. This includes the period of an armistice or military occupation up to the effective date of Treaty of Peace. Trial of war criminals by military tribunals. American Bar Association in June 1944. Exemption. Article 2 Revised Penal Code. Article 14 of the new Civil Code provides that the penal laws in those of public security and safety shall be obligatory upon all who live or sojourn in Philippine territory, subject to the Philippines of public international law and to treaty stipulation. Treaties or treaty stipulations. An example of treaty or treaty stipulation as an exemption to general application of criminal law is the base agreement entered into by and between the Republic of the Philippines and the United States of America on March 14, 1947, stipulating that the Philippines consents the United States have the right to exercise jurisdiction over certain offenses. Note that the 1947 military bases agreement between the Republic of the Philippines and the United States of America expired on September 16, 1991. Okay, let's move on to another topic. The law of preferential application. Example of law preferential application is Republic Act 75. It is a law to penalize acts which would be impair the proper observation by the Republic and inhabitants of the Philippines of the communities rights and privilege of duly accredited foreign diplomatic representatives in the Philippines. Its pertinence provision are Section 4, 5, and 7 of Republic Act 75. Okay, in international law, the following are not subject to the operation of criminal laws. Sovereign in it and other chiefs of the state. Number 2, ambassadors, ministers, plenipotentiary ministers, resident, and charge of affairs. It is a well-established principle of international law that the diplomatic representatives such as ambassadors or public minister that official retinue possess immunity from criminal jurisdiction of the country of their sojourn and cannot be arrested or punished by the law of the country. A consul is not entitled to the privileges and immunities of an ambassador or minister. In the absence of treaty to the contrary, withhold international law, section 249. Okay, that's the in general topic number 1. Let's go to number 2, characteristic. Territorial, number 2. In that criminal laws undertake to punish crimes committed within the Philippine territory. The principle of territoriality means that, as a rule, penal laws of the Philippines are enforceable only within its territory. Within its territory, number 2, territorial. Okay, let's go to number 3, prospective. And that penal law cannot make an act punishable in a manner in which it was not punishable when committed, as provided in Article 366 of the Revised Penal Code. Crimes are punished under the laws and the force at the time of their commission. Absolute repeal makes the offense not criminal. The accused was prosecuted for and convicted of a violation of ordinance. While the case was pending appeal, the ordinance was repealed by eliminating the section under which the accused was being prosecuted. Held, the repeal is absolute where the repeal is absolute and not reenactment or repeal by implication of offenses cease to be criminal. The accused must be acquitted. But repeal of the penal law is, by its reenactment, even without a saying clause, would not destroy criminal liability. When the new law and the old law penalize the same offense, the offender can be tried under the old law, where an act of legislature which penalizes an offense repeals a former acts which penalize the same offense. Such repeals does not have the effect of thereafter depriving the courts of jurisdiction to try, convict, and sentence offenders charged with violation of the old law prior to its repeal. Okay, that's it. Let's go to another topic. A new law which omits anything contained in the old law dealing on the same subject operates as a repeal of anything not so included in the Amendatory Act. The Agricultural Land Reform Code supersedes in agricultural tenancy law except as qualified in Section 4 and 35 of the Code. The Code institutes the leasehold system and abolishes share tenancy subject to certain conditions indicated in Section 4 thereof. It is significant that Section 39 is not reproduced in Agricultural Land Reform Code, though Section 172 repeals all laws or part of any law inconsistent with its provision. Under the leasehold system, the prohibition against pre-threshing has no more raison d'etre because the lessor is obligated to pay a fixed rental by prescribed in the Section 34 of the Agricultural Land Reform Code, or the Code of Aggregation Reforms as redesignated in Republic Act 6389, which took effect on September 10, 1971. Thus, the legal maxim "Cessante ration leges and citat ipsa lex," the reason for the law ceasing the law itself also says, applies to the case. Okay? Expiration makes the law self-repealing law. Okay, let's go to last part, the page 10 of our book. Compendia of Revised Penal Code, Book 1 and Book 2. Okay, and page 10. Construction of penal laws. Penal laws are strictly construed against the government and liberally in favor of the accused. The rule that penal statutes should be strictly construed against the state may be invoked only where the law is ambiguous and there is doubt as to its interpretation, where the law is clear and ambiguous where is no room for application of rule. In the construction of interpretation of the provision of the Revised Penal Code, the Spanish text is controlling because it was approved by the Philippine legislature in its Spanish text. No person should be brought within the term of criminal statutes who is not clearly within them, or nor should any act to pronounce criminal which is not clearly made so by statute. English text that the crime is robbery with homicide, when by reason or on occasion of the robbery of the crime of homicide shall have been committed. The Spanish text of the same provision reads as follows: cuando con motivo o con occasion del robo resultare homicidio. Held in view of Spanish text, which must prevail, the crime committed is robbery with homicide, even if the homicide supervened by mere accident. While the English text of Article 29, Part 1 of the Revised Penal Code seems to convey the meaning that the homicide should be intentionally committed. The Spanish text means that it is sufficient that the homicide shall have resulted even if by merely accident. Okay, some cases of incorrect translation of Spanish text into the English text. Sosteniendo combat into engaging in war, or Article 135. Number 2, sufriendo privation de libertad into imprisonment in Article 157. Vuebo delito into another crime in the head note of Article 160. Okay, that's all. Thank you. That's my 8A audio-visual presentation. Thank you so much, sir.